Should you sign that severance agreement before you agree to leave with a paycheck? Are you really protecting your rights, or are you setting yourself up for regret? I thought it would be timely for me to do this video. In it, I will discuss 7 reasons I would not sign a severance agreement. Now, while I am not an attorney, I have over 20 years of managerial and supervisorial experience. And yes, I have hired folks, I have fired folks, I've also trained managers and supervisors on how to do the same. Before we dig into my reasons, I want to talk about some basics. So, what is a severance agreement? It is sometimes referred to as a letter of severance, a separation agreement, a severance agreement and release of claims, a termination agreement. So you'll see those names used depending on what company you work for, what organization you work for, and who their legal counsel is that prepared their document or what have you. In its simplest form, a severance agreement says that you no longer work with the employer. You're no longer employed by them. The company is paying you in exchange for you releasing them from any claims. In other words, you're getting money to give away some of your rights, namely not to file claims against them. A few common terms that may be included in the severance agreement. Note, this is not an exhaustive list. You may see the term arbitration. Arbitration is an agreement that requires the employee to resolve disputes with their employer through arbitration instead of going to court. You might have seen it when you were first hired. It's in the handbook generally. And some employers go beyond that and they will have you sign an additional supplemental arbitration agreement, acknowledging that you are aware that the company will use arbitration to settle disputes. Another phrase you may see in the severance document is at will employment. This indicates either an employer or the employee, you, can terminate the employment relationship at any time for any reason as long as it's not illegal or for no reason at all without prior notice. Some states do not allow at will employment. So it's really important for you to understand what type of employment arrangement you have with your employer. You also should have seen this in your employee handbook. And some employers, I know I worked with one that had employees sign a document acknowledging that they were aware that it was an at will employer during onboarding. Another term, parties. This identifies the employer and the employee entering into the agreement. And sometimes you will see the company's names, you will see the CEO of the company, the owner of the company. So when it'll say party, it'll tell you who each party is and will define who each party is when they're reference it throughout the provisions of the severance letter. Termination date. This should clearly state the date the employment termination becomes effective. So it should not be like June 2026. It should say June 1st, 2026. It should not just be the week of such and such. It should be January 1st, 2025. Specific dates. Severance benefits. This outlines the compensation and the benefits the employee you will receive upon termination. This may include severance pay, a continuation of health insurance, and you often hear this called COBRA. It should include unused vacation. Depending on where you work and if you have certain employment contracts, it may include sick leave payout or other entitlement. I just thought these terms might be helpful so that you can get an idea of what can be contained in these severance letters. Another term that you may see is release of claims. Typically, what happens, employers want a full release of all claims you could have you possibly may have against them. This is an employee release and can include discrimination and or workers' compensation claims as well as others. There is also a mutual release. That's where both parties release each other from claims. For example, I've seen this where an employee might have been accused of theft, for example, and the employer says, hey, if you sign this severance agreement, I give up my right to pursue you legally for whatever it is you stole from the company. And the employee, in turn, is saying to the employer by his or her signature, I release or give up my right to sue you for harassment or wrongful termination or what have you. So that is a mutual release. The other term you may see is confidentiality, non disclosure, and usually these are put in to the agreement because they want to protect sensitive or proprietary information. For example, maybe you are the payroll manager. So you have information about what individuals are earning in the company. This information they may want to keep private and may not want it out there for public view. That's just an example, but there are a lot of others. Another provision you may see or term is non-disparagement. This typically prohibits the employee from making negative or disparaging remarks about the employer or its employees. I have seen where it includes the board of directors. I've seen where they have indicated by name the owner. You cannot say anything about the owner or his or her family. So they have them in different ways, depending on the type of company, the roles of those involved, and the type of legal counsel that the employer secures. So you just want to be careful about that. And I will mention the non-disparagement clause. I will reference it a little later in the video. Another term you may see, depending on what your position was with the company or is with the company, is a non competition provision. This typically restates restrictions on the employee's ability to compete with the employer for a specified period of time and within a specific geographic area. Sometimes an employee can ask to narrow the scope of the non-compete clause. Sometimes you'll hear it being called a non-compete clause to make it easier to find new work. And a lot of that has to do with some of the other terms that I'll talk about a little later on, but it'll all make sense in a second. Another provision you may see is non-solicitation. These provisions restrict the employee's ability to solicit its clients or employees for a specific amount of time. For example, you are leaving a company, maybe you are signing a severance agreement, and it is known by the company that you are leaving to start another company. Now, let's say for whatever reason, you are starting a company that is the same as or similar to the company you're leaving, and there's no problems with the non-compete clause. And maybe some of the employees at the company that you're leaving, they have transferable skills that may assist you or you may benefit from with your new company. Okay. Some of the severance agreements say, hey, you can't take my employees from my company for a period of time. Now, you may be able to request relief from this and have it even taken out. That's why you should stay to the end to hear what I suggest folks do. The other thing you'll see is language surrounding the return of company property. And I just want to make this really clear that the company property could include documents, intellectual property, laptops, cell phones, all those type of things. It could include access codes, key cards for entering the building, your identification badge that allows you access to certain areas of the company or organization. So those things would need to be returned in a specified manner, and all of that should be contained within the letter of severance. Now, I want to give a note of caution here. Before you use your personal property to perform work tasks, such as your cell phone, your laptops, and iPads, I would caution you to be very careful about that. I'm not going to get into the specifics, but I would caution you to either refrain totally or minimize how much of your work you perform using your personal property, such as a laptop or cell phone. And I know it's so easy to say, I'm just going to send this quick email, I'm just going to send this quick text. You want to be careful because if there is some type of employment dispute regarding how you were terminated or how you left the company, those things may be able to come into play. The other thing you may see in your severance letter, depending on the type of company or organization you work for, is language regarding proprietary information. Now, this refers, as I said earlier, to any confidential information a company wishes to keep private, which may or may not be legally protected under intellectual property law, including trade secrets and sensitive business strategies that give the company a competitive edge. So I have seen that in some severance agreements. I've seen it listed out. Before we move on to the 7 reasons I personally would not sign a severance agreement, I want to give this disclaimer and remind you that I am not an attorney and this is not legal advice. This video is for educational purposes only. As such, I encourage you to seek an employment attorney or legal professional if warranted. Please note, if you are covered by any type of CBA or collective bargaining agreement, also known as a union contract, I strongly encourage you to speak to your union representative about the particular CBA you are a member of, as they are governed by the Ralph C. Dillis Act. And I'm not going to get into the details about that. This has to do with a lot of state employees, government employees, county, city employees. And it's not necessarily just them, but if you have any kind of bargaining unit that you're covered by, you always make sure that you are speaking to your union representative. Some attorneys will ask you, hey, are you covered by a bargaining unit agreement? Sometimes they'll say a BUA, bargaining unit agreement. And if you say yes, sometimes the attorneys will ask you, hey, have you gone to them? Do they know that you're seeking legal counsel from me? So I just wanted to put that out there because I have seen and experienced that when I myself was an employee. Now, let's discuss 7 reasons I would not sign a severance agreement. Again, this is not an exhaustive list. I would not sign a severance agreement if you don't understand the provisions of the agreement. These agreements usually contain tons of legal language. I gave you some examples earlier when I talked about the terms. So you just want to make sure you understand everything. I would not sign a severance agreement if you have questions or if it gives you pause. Do not make rash decisions. Take a minute, think about what's happening. You need to know what you are signing away. You need to know what you're getting in return for signing away things. And I mean signing away rights. For example, are you signing away your right to file a workers' compensation claim? Are you signing away your right to file a discrimination claim against your employer? And if you are signing away these rights, what are you getting in return? I would not sign a severance agreement if you feel pressured. Remember, all money ain't good money. Usually, when you're having a severance package, it includes, hey, I'm going to give you this check in exchange for you to sign this agreement, which usually includes a release of claims. 4, I would not sign a severance agreement if you don't agree with some of the provisions as written. For example, you would like the non-disparagement provision to be reciprocal, meaning that you want to be able to have in that agreement that, hey, while I can't disparage my employer or former employer, they can't disparage me. So you may decide, I don't like the fact that this is only about the employer. I want something in there about me. I know of a case where the employer is disparaging or has disparaged some of the former employees. And one of them had to do what they had to do to stop that. I just wanted to point out that you have a right to say, I don't like this part. I want to be treated the same way you're asking me to treat you to the employer. Because don't forget, earlier when I talked about terms, I said parties. You are a party. The employer is a party, and you're a party to this agreement. And so if you do not agree with some of the provisions, then you may want to not sign it. 5, I would not sign a severance agreement if you were wrongfully terminated. For example, you were terminated solely because you took time off work using a protected leave, such as family medical leave or FMLA, which is federal, or in California, we have what's called CFRA, California Family Rights Act, CFRA. The other time that I would not sign a severance agreement is if the agreement is binding into perpetuity. This means forever. And I have seen one of those. Okay. I have seen one. Honey, I was given one. And I'll talk a little bit about my personal experience in a second. But yes, you don't want to sign that. So, what do I encourage you to do? Here's my non legal advice: get legal advice from an employment attorney or legal professional in your state. And the reason why I stress your state, because employment laws can vary. For example, earlier I spoke about non-compete clauses or non-compete provisions within the severance agreement. As of January 1st, 2024, it's illegal for employers to enter into or enforce non-compete agreements in California. This includes employers who operate outside of California but employ California residents. And that is my non-legal advice, is to get legal advice. The attorney will ensure that you actually understand what you are giving up and what you are getting in return. Is it worth it? Sometimes when you're presented a large sum of money at one point, and sometimes it don't even be a large sum, let's keep it real, but you're presented this money. Sometimes you think, oh, I need this. I need to pay this, this, and this, and this, and that, not realizing what the value is of what you are signing away. That's why I encourage you to breathe for a second. All right. Because when you get that severance letter, you're pissed off, especially if you did not see it coming. You're pissed off. Going to be pissed off if you need to be pissed off. And I'm sorry for the coarse language, but I'm just going to keep it real. You are pissed off. You're thinking about all the times you worked late. You're thinking about all the vacations you gave up, all the times you came in when you were sick, right? You feel betrayed in some kind of way because you are ending a relationship. So I'm saying when you get the severance letter, catch your bearings before you make a decision. Legal counsel will also ensure that addendums, changes, or modifications that you would like to make to the agreement are considered and are included. For example, earlier I mentioned adding a reciprocal non-disparagement provision. This is something your attorney, because it's your attorney, is looking out for you. And let me say something about attorneys. Do not rely on the attorney that is representing the company to represent you. Do not rely on the human resources person or the HR person who may be giving you the severance letter to represent you or to explain things to you. Do not rely on them. They work for the company. They are bought and paid for the company. So whose best interest do you think they're looking out for? The company. I have seen people who they just trust that the company is going to do right by them. And I'm not saying that the company is not. I'm not saying that. What I'm saying is you have a right to check things out to see, hey, is this in my best interest? What am I giving away? What am I gaining? Do those things equal? Is it an equitable exchange? Or is it an exchange that I can personally live with and be fine with? Because this is about you. This is not about the employer. This is about you. Only you know what your relationship was with this employer. I mentioned how I saw an agreement that was good into perpetuity forever. Another thing legal counsel could do as it relates to that is to ensure that there is a sunset date of specific provisions that are considered and included as opposed to something being good into perpetuity. Legal counsel could present this for you, and they may even suggest it. Let me get into a personal story. I was presented with a severance agreement and release of claims and offered 1 month's severance pay. The employer gave me 7 business days to sign the agreement. Otherwise, I forfeited the severance pay. I am not a lawyer. However, I knew the provisions of the agreement heavily favored the employer. For example, several provisions included in perpetuity clauses. It also allowed that in the event of the owner's demise, the agreement would essentially be inherited by their successor. The agreement also contained language that the employer could, if they chose to, share the agreement with all my potential future and or subsequent employers at any time without informing me and without my consent. And finally, it allowed the company to change the agreement at any time for any reason without my consent. After reading the 14-page single space document, I feel like I was being asked to sign a bad record deal. For real, for real. I ain't gonna lie to you. I felt like I got gut punched hard. It took me about a good 500 or 10 minutes to catch my breath. Now, I made a personal decision not to sign the agreement or accept the severance pay. That was a decision I made. I also made a personal decision not to contact an attorney. I chose to wash my hands of the entire situation and walk away. Because, as I said earlier, all money ain't good money. And my peace of mind is priceless. Now, having said that, I would absolutely never advise anyone to do what I did. Everyone's circumstances are different. Okay. I worked in management and supervision for over 2 decades. I represented my past employers at personnel hearings, including employment termination hearings and trials, EEO or equal opportunity hearings, workers' compensation hearings, settlement conferences, and trials. I also trained, coached, and ensured that managers that I supervised adhered to employment law, labor code, and relevant bargaining union contract, as well as other relevant legislation. As such, I have a grasp of and understand some of the language used, and I felt comfortable with my decision. I'm good. And could I have probably gotten more money and signed the agreement? I'm sure I could have. In fact, I know I could have. But for me, my peace of mind was better than dealing with that. I walked away and I'm doing good. So please do not use my example to make a decision about your situation. Don't do that because everyone's circumstance and situation is different. Okay? Totally different. I told you all my business. Let's get into yours. Have you ever been presented with or been asked to sign a termination agreement? Did you sign it? Let me know in the comments. I hope you found this video valuable. If you learn one thing from this video, it is to seek legal counsel from a competent professional who specializes in employment law in your state or jurisdiction. If you learn that, my work here is done. Please give this video a thumbs up. It really helps the YouTube algorithm recommend my video. Also, share this video with anyone who you think may benefit from the information. And if you're not subscribed to the channel, what's up with you? Thank you for watching. See you in the next video.